The only real criticism of the rule, or I mean the opinion, has come from the pretty much the plaintiff's bar trial lawyers, and their view is that, you know, they put in a lot of work and all of a sudden the client dumps them, and that's unfair. And that may be so, but even if it is unfair, I think that the rule articulated in the cases I've cited, which is that unfairness is adequately compensated by quantum merit, is the rule that ought to be in a COPRAC-sponsored ethics opinion. There's been an effort in past meetings to search for, well, maybe there's got to be an exception. Can't we find a scenario where there's got to be an exception? And after months, literally months of looking for it, nobody on the drafting committee has come up with one that we felt ought to be in a COPRAC-sponsored opinion. And we finally, or I did, and I was joined by some of the others, got to the point of, we've looked enough. I'm satisfied that the view that quantum merit by itself is sufficient compensation against the criticisms to compensate attorneys for the unfairness of the enforcement of the rule, that COPRAC ought to say so, or, in my personal view, just not say anything at all. So that's why I put together the basis of my the support for my conclusion, and I commend you to consider it. And I'd like to see us vote this either up or down at this point, because I don't think we're going to find that scenario that's going to be the exception, because we haven't found it yet. That's it.
And just to be clear, we have not revised the draft. The draft still provides for wiggle room that we on the working group think is inappropriate, but it seemed foolish to spend the time wordsmithing the draft when it didn't appear from the last couple of meetings that the committee wants to go that direction at all. So, you know, if I'm reading what Joel is suggesting, he's looking for I don't know if it's a straw poll or whatever, just some way to take the temperature on where the committee as a whole stands on whether we can shut the door completely or you want to leave the wiggle room. And Joel is suggesting that he thinks no opinion is better than an opinion that leaves the wiggle room. The entire working group favors the strong opinion that Joel favors, but not everybody is of the belief that it should be all or nothing, you know, if we can't convince the committee.
Yeah, I would just add, I mean, we were all in kind of agreement on the one thing I think we did talk about potentially changing it is we all kind of agreed with that one comment that scenario 5.
Yeah, perfect.
You know, really, is really pointless and doesn't add anything, and it's so far-fetched. I think we all kind of agreed that maybe drop that one, but leave it otherwise.
Well, the other side of that, Ken, if I recall, is that the other 4 scenarios all say you can't do it. And I think once we came to that conclusion, it was, if we're just going to say you can't do it, let's just say you can't do it. I mean, if all 4 examples conclude that you can't do it, I don't know why we need to have extended length of an opinion with examples of how many ways you can do it.
Joel, I'd like to know, when you say all 4 examples conclude you can't do it. See, I read the working group memo and I didn't see any example that said, or maybe talk about the hypotheticals in the draft opinion. Is that what you're talking about? I think I was misunderstanding what you're saying. I was thinking you meant all 4 examples in the. the case examples, but you're just talking about in the scenarios in the current draft opinion.
The hypo, yes, the hypo.
Yeah. Okay, never mind. And could you remind me to, I know, Brandon, you said that this, you know, it hasn't been revised to reflect the opinion in the memo, but this went out for public comment, and I don't recall ever getting the public comments distributed, and maybe that happened a while ago because I was looking for them.
It happened it was a long time ago.
Yeah.
From either Angela or Erica, and it was really split opinion. There was a huge part of the bar that says your whole opinion's wrong. Conversion clauses are necessary to protect lawyers from wily bad faith clients, right? And then there were some people, notably LA County Bar Association Ethics Committee said, everything you're saying here suggests the conclusion that these conversion clauses are impermissible. So why don't you just say it? And we were more persuaded by that point of view. But, and I think Erica or Angela actually prepared a memo on the public comment sort of, I can't remember exactly, but it was last year. It was a long time ago.
Okay, I think it was October of last year. Okay, yeah. And so what we're looking at currently, the red lines, or the red lines since we received the public comments, is that right?
Yes, but I mean, I'm sorry to be so wishy-washy on this, but I can't even remember when we made these red lines because we've just been sort of talking about this at every other meeting or something.
Yeah.
Okay. So they're not like
go back and tell you, when I looked at the old red line, I mean, it was so far back, and it was on the last time I did it was on my old computer, and as I told Erica, I could not even give her a clean opinion, and I didn't want to spend any more time doing it if it's just going to go back and say, oh, we need to keep the examples in and rework them. So that's my fault, but I just think we need to answer the central question. Are we all in or are we not?
And just to clarify for everyone, there seems to be no disagreement. The conversion clause opinion really addresses two types of conversion clauses. The one where there's broad agreement is that conversion clauses that are keyed or triggered by a client's decision to settle or not to settle pursuant to the attorney's recommendations, those are unacceptable. And nobody really seems to disagree with that. Doesn't mean people don't do it, but ethically and in terms of public comment, that wasn't controversial. The much more controversial issue is conversion clauses tied to the termination of the attorney-client relationship, right? And we haven't changed any of the analysis in the draft, any of the authorities or the sources for why we, the draft says these sorts of contingency clauses are highly unlikely or unlikely to be ethically permissible. And people are pretty comfortable with that. I guess the working group is just trying to shut the door on it. And that's sort of the big question we pose to the committee now. And how can we move forward? Or should we just table this? I mean, Joel, and I respect his opinion, feels very strongly that issuing no opinion would be superior than issuing an opinion that leaves this door open when we don't really think it should be left open. It might be inviting people to do something that we think is improper. I mean, you can see how attorneys are certain types of attorneys can make mischief.
And the one area that we can't really opine on and we haven't really discussed, but it's come up now in about 3 cases that I've testified as an expert in, and that is the issue of why did the client really want to leave? And you get into the situation of Russ Miliband and Smith versus Conkle and Olison, where the court said that when the lawyers stopped answering questions and then blamed the termination of the relationship on the fact that the client asked too many questions, the court said, no, that was a withdrawal without good cause. And they were entitled to no fee whatsoever. And then there's a subtle thing. Well, when does the client have a right to just say, I'm tired of dealing with this attorney. They're not dealing with me. They're not considering my personal situation. They're not sympathetic. When does the client have the right to exercise the right to fire the lawyer without paying a penalty. And every time I've looked at it, I've come to the conclusion that the client always has that right. And to charge extra, charge the client a penalty for terminating the relationship because they're unsatisfied for any reason, violates the rule, and it's unfair to the client. If you take the view that it's also unfair to the attorney, then I think the cases I've cited speak to that issue by saying, okay, let's enforce the public policy in favor of the client and compensate the attorney for unfairness with quantum merit. The reasonable value of the services they put in on the case up until the date of determination, not anything more.
Well, I'll throw in my 2 cents because I was one of the people who was skeptical of the prospect of going past what the cases say. But I've thought about it since we had that discussion in this way. When you put together the premises that Joel just outlined, I do think there is authority for the position that exists in the public policy, in the concept of quantum merit. And the way that I think of it is that if you are talking about quantum merit that is something more than the reasonable value, in other words, I need more than quantum merit would permit, then it is a penalty. Then it is somehow a penalty that in my brain would violate the unfettered choice of counsel. And I can't think of another circumstance where we would permit, or when any authority would permit, the client being worse off just because they decided to change counsel. That's expressly forbidden, right? So the cases may not say it, but when you go back and think along these lines, I feel like there is authority for it. It's hard for me to logically get to a different conclusion when you think of these inputs.
Yeah, I'll also speak very briefly because I think I also question the kind of ultimate conclusion that they're just per se prohibited in all circumstances, the conversion clauses. And I looked at the working group memo, which was helpful, but I also don't feel that any of the cases really stand for the proposition that conversion clauses in all instances are prohibited. I don't think any case supports that. And I've also looked at about 6 or so ethics opinions of other jurisdictions, including Colorado, Philadelphia, New York, Virginia, and they all come to the conclusion that conversion clauses are in some circumstances permissible so long as they don't result in an unreasonable fee. And I know the memo points out the fact that California's standard is different, and that this is something that I recall raising myself at one of the prior meetings, that we actually have a standard that the fee cannot be unconscionable or shock the conscious and be so exorbitant. So in my mind, if the ethics opinions in jurisdictions where it's saying you can't charge an unreasonable fee or saying these types of clauses are permissible, they should be permissible as well in California in certain situations. And I don't agree that we would be the minority, because I think the memo talks, we would be the minority if we were to opine that they might be permissible in certain circumstances. I don't think we would be. Of the ethics opinions I've reviewed, most of them have found that they may be permissible in certain situations as long as they don't result in an unreasonable fee. And I understand the concern about interfering with either the client's right to settle, which I know that's something that I think we all agree on. It can't do that. And I also think we all agree on that it can't interfere with your right to change counsel. But I don't think a conversion clause necessarily will result in, just because it might result in something that's more the quantum error, would necessarily interfere with the sophisticated client's ability to terminate counsel. Particularly, and you can think of factual situations, just to give an example, and when you're looking at all the factors in the rule dealing with unconscionable fees. For instance, if you're, you know, one of the factors is maybe it's let's say this is a huge case, the client really wants the attorney to take it, and it's going to require the attorney to just give up all of the attorney's time to devote to this case. So maybe they'll want a conversion clause in that situation. And I don't think we can just say they're per se prohibited. In all situations under the, I don't know if it doesn't violate a rule, and that the cases that the California State Court cases that are cited in the memo involve situations where a rule was clearly violated. And here I don't think a conversion clause necessarily violates a rule either. So
two things. Let me.
Joel, could you just okay, Justin was just about to speak. If you could let him speak maybe first.
Oh, can we take away the screen share, because we can't see who's got their hands up?
Yeah, we can't see who's moving.
Oh, sure. Sorry about that.
Yeah, maybe I'll go next, just because I think I'm going to piggyback on what Sarah said. I had basically the same comments written down, and in particular, you know, Fracassi is not a conversion clause case. There wasn't an agreement in advance as part of that agreement what the attorney would get after he was terminated. He just wanted basically his contingency after he was terminated. The Scappa case deals with a situation where basically the client couldn't get rid of the attorney and end the relationship without paying money. So in that instance, I agree that's a situation where to discharge the lawyer, it's like a penalty, but that is, in my view, different than a situation where the client can remove himself or herself from the attorney-client relationship, get a new lawyer without, and it's not tied to what we're calling a penalty or a fee. So I think that's materially different. And so neither of those cases, I think, supports a per se prohibition on conversion clauses. And I had just read the Virginia opinion that Sarah alluded to, and she alluded to a number of opinions that conclude that in certain circumstances conversion clauses can be permissible. And so I don't see anything in our opinion. If we were to have an opinion that took the it's always prohibited position, if we were to do that, we would need to very persuasively explain why it is we're going against all of these other opinions that are in jurisdictions that have a reasonableness standard, which, you know, I agree with Sarah, unconscionability standard is different and I think higher in this context. And again, if it were the situation that it was per se and it was always unethical to have a conversion clause, I don't see why we would need an opinion if the law is so clear. I think the fact that the public comments are split on this suggests that isn't a view that is, I think, consistent with, at least in my view, the law as I've read it, or kind of the public opinion out there. And I also have concerns, which I've addressed earlier, about freedom of contract, and there being situations where, yes, ethical duties may prohibit certain types of agreements, but to say that a lawyer and a client can never have this type of agreement, I think goes too far in terms of interfering with the freedom of contract. So I very much echo what Sarah said. I don't want to repeat any of it more than I already did. That's kind of where I am.
Justin, it seems to me you've answered the question favorably to the position that we're taking. If you read the Virginia opinion and the Colorado opinion to say that articulates in those jurisdictions a reasonable fee standard, that means that when the attorney services are terminated mid-case, the attorney is entitled to the reasonable value of their services. If what you're saying is that you're entitled to contract for something more than the reasonable value of your services, then you're contracting for something that you're not entitled to under the rules. And even if it's not unconscionable, California cases where you don't have a contract where you're limited to reasonable value don't give you any reasonable value. They don't give you a wiggle room. And according to the Pesh versus Martin case, that says to get to above reasonable value, you've got to have a complying contract with 6148. So it seems to me, I mean, that's the way I read all those other cases and tried to distinguish them, and I think I did, is that they all say that, sure, you can have a conversion clause, provided that the end result is a reasonable fee. California says at the end of the case, when the contingent comes in, the two lawyers split it up on a reasonable value basis, and that's what they get. And if you now say that it's okay to contract for more than the reasonable value, you're doing a couple of things. You're chilling the right of the client to change counsel by instituting a penalty. You're making it more unlikely that second counsel will be found to take it over because the case won't be as lucrative because the client will be paying more to the first attorney than the first attorney otherwise would be entitled to under the way these things are normally looked at. And if the dispute is over that caused this separation is over things like settlement, or we can't get along, or they're not communicating, or all these subjective reasons, you're really putting a chill on the right of the client to get a lawyer that they're happy with. Instead of once they sign up, they're stuck. So I think you've answered the question favorably to the opinion we're suggesting when you read those other foreign jurisdictions as saying they're okay as long as it's a reasonable value standard.
I was just going to say, Sarah and Justin, I initially looked at all the out of other jurisdictions, the reasonable fee limitation jurisdictions, and came to the initial conclusion that both of you did, which is that, oh, because we have an unconscionability standard, conversion clauses in California, there should be no prohibition on conversion clauses that exceed quantum merit. But I actually came around looking at the very same cases to the opposite point of view. Just to sort of paraphrase what Joel is saying, but the way my brain processed it was that in every state other than California, every conversion clause is limited to quantum merit already by that state's limitation of attorney's fees to a reasonable fee. And so states that allow conversion clauses are already protecting the clients and saying nobody's going to get charged more than a reasonable fee. And in California, if we were to allow conversion clauses that exceed quantum merit, we would be the outlier allowing, and we already are the outlier in terms of what is a disciplinable offense and how you bill your client, right? But what we're analyzing in this case is the impingement upon the client's right to terminate counsel. And in all the other states, they weren't worried about making the case super unattractive or penalizing the client because they've already got a rule in place that protects against that. We don't. And unless we were going to change our standard from unconscionability to reasonableness, it led me to the conclusion that we can't tolerate these sorts of contingency conversion clauses because they would impact the client. And I say that just to show you a different way of looking at the very same cases, because I've shared your point of view as well, but came around to a different conclusion on it. That's all I wanted to say on it.
So, just hypothetically, let's say there's a conversion clause and it's agreed in the contract that if the lawyer's terminated before the contingency comes to fruition, the lawyer's going to get X fee. And let's assume, for the sake of my hypothetical, that X fee happens to be reasonable. Is that conversion clause not allowed under California law because California law doesn't allow for conversion clauses?
It's hard to imagine how that's actually a conversion clause, because I think we're defining the language that started us down this road was the sentence that the drafting group wanted in, which said that a conversion clause that would purport to entitle the discharged attorney to more than quantum merit is not ethically permissible. So, you know, as I understand it, some jurisdictions did not have a default for a discharged attorney to get quantum merit. So they would build in what is already our legal default, quantum merit for a discharged attorney. So I'm not sure if that would really be a conversion clause, but it would just be assessed against quantum merit, I believe. Because I guess all we're saying is that if you're terminated and you're not disentitled to fees entirely because of some other, you know, Russ Millibrand behavior, you get quantum merit. And if the conversion clause you're describing there would entitle you to quantum merit, I think it would be fine. Joel, do you disagree?
No, and actually, Justin, I asked the question, and I'm not going to be tautological about it, but at the end of the case, the two attorneys duke it out, and somebody makes a decision about what's the reasonable value of the services of each, total cap high or contingent amount. And so attorney one gets a reasonable fee. What do you call $10 more than a reasonable fee, but an unreasonable fee?
Okay, but that's not my hypothetical, because I'm looking at how we define a conversion clause. It says a conversion clause is a contractual provision that, if triggered, converts the fee due to a lawyer from that contingent to an alternate fee arrangement. So that would seem to cover my hypothetical, where the lawyer gets terminated before the contingency and then has to pay X. And in my hypothetical, X is reasonable. But if that's true, so wouldn't that mean then that any conversion clause, even if the triggered amount is reasonable, violates California law?
Well, Justin, in your hypothetical, I mean, first of all, if it converts to another fee, what's missing in your hypothetical is whether the contingency occurs, because that's one issue. Because if you know, that way you'd be penalizing the client if he's terminated and the contingency doesn't occur, the client's still on the hook for some fee. And I guess theoretically, if the converted fee is something that doesn't exceed quantum merit, maybe. But that's not different than what we have in our opinion. And those out-of-state opinions too. I mean, the Colorado one and the Virginia one, when you dig into them, while Colorado said not per se, what they discuss is fully consistent with ours. They generally say that can't be done. It violates the client's right. The same thing in the Virginia opinion. I mean, neither opinion comes up with any scenario where it would work. They conclude the clauses that they were addressing were not permissible. They were ethically problematic. But I guess they just, I think where we somewhat differ from them is they just, said they're not per se unethical, but these are unethical.
So I guess where I'm struggling is kind of the conclusion in the recommendation that it says conversion clauses are never ethically proper. But what I'm hearing is that if the conversion clause would trigger a reasonable fee, then it could be permissible ethically. And so therefore I'm struggling with.
Justin, you don't need a conversion clause to trigger a reasonable fee. You get that under the law.
But what kind of lawyer wants to wait and fight about it, whether he's going to get attorney's fees 2 years down the road? They want their fee now, and they want to have that in the agreement because they're a really reasonable lawyer, and so they're going to set it at a reasonable amount, whatever, $50, $500, who knows? And they don't want to wait 2 years to duke it out and spend all this time and expense figuring out what quantum merit is. So why in that circumstance is it per se or always ethically improper? And I think that's that's the disconnect that I'm having here.
Because
Client came to the first lawyer seeking a contingent arrangement so that they wouldn't have to come out of pocket.
yeah.
And when you put a conversion clause like you're talking about in there, then they have to come out of pocket just to exercise their right to get a new lawyer. That shouldn't be. That is a burden on the client's right, exercise of the client's right to retain new counsel.
So let me just jump in real quick, because I think we're being unfair to Justin here, because he's shooting from the hip, and there's so many factors that have to go into the hypo of the conversion clause, right? Is it payable? Whether or not a contingency occurs, when is it payable? How is it assessed? All those things. And I apologize because I haven't even looked at our draft in so long. We've been talking conceptually in our meetings for like a year since the public comment. And so, Justin, you're correct in what you're reading from the draft is not exactly what we're talking about here. I would appreciate guidance from the committee, starting from the proposition. The sentence that started us down this road was, we wanted a sentence that said, a conversion clause that purports to entitle the terminated attorney to more than quantum merit is not ethically permissible. Are we comfortable with that? Because then we can talk about what's a conversion clause and what's not. Because, and Justin, my other concern is you can't really assess whether the conversion clause in your hypo is reasonable until we make a quantum merit assessment, like what was the recovery and all that stuff. But can we take a straw poll of the committee as to the sentence I was saying? Just, you know, do we believe that it is unethical to have a conversion clause that gets you more than quantum merit? Or do we think the freedom of contract allows you to do so? Because that's the counter argument, right?
Yeah. Raquel thought I had for, yeah, that's
I'm
fine.
sorry, Raquel.
No, that's fine. I was waiting. So a couple of things. One, I realized this probably started maybe before I was on here. So I'm trying to figure out what problem do we think we're trying to solve? Which the reason I'm asking that is because Joel says, well, his recommendation is if we wouldn't go in the way he's suggesting, we wouldn't have anything. So that makes me say, oh, well, what's the risk? Why did we take this on in the beginning? So that's one question. The other one, not being, again, particularly in-depthly familiar, but in the professional services field overall, which is a field I'm in, you know, effective contracting, it seems to me we would say in the opinion that when you have these contingency agreements right up front in there, you would say what the conversion rate is. And so the person who's going on contingency fee, you know, they already know, and the lawyer already knows what it is, versus this vague thing that happens at the end, which is filled with a lot of emotion on one side or the other, or even both. So my question is that part of what would be in the opinion already? Or is that, because to me, that solves the answer that I'm talking about. Because if I go on contingency, I know what I'm signing up for if I want to get out. And I'm doing that with my eyes wide open, and there is no, you know, Joel saying, well, the person would be hurt, but I'm making that decision. And the lawyer is also knowing you're not going to get more than what you said at the beginning that you would get if it gets terminated, no matter how you're feeling about why, when, and how. So that's
just to give you a little background on where the opinion came from. Some of us in our practices deal with attorney-client fee disputes a lot, or even in malpractice cases, and we see a lot of attorney-client fee agreements that style themselves as contingency fee representations. I don't have any money, but I've been wronged, so that's why I need to hire this particular attorney because I don't have a dime to pay him. And it says, if you fire me, there's a million permutations. I get my hourly rate for everything I worked and you pay me immediately, or I get my hourly rate against the ultimate recovery, or, you know, there's other permutations that And then attorneys do a million things. They drop the ball, they go silent, they yell at their clients, they do things that we've seen in our, not all attorneys, but in those of us that practice plaintiff side legal malpractice, we see some really awful behavior. And then you get attorneys that, you get clients that don't feel able to exercise their right to get a new attorney because I don't have $100,000 to pay this guy. And he says, I owe it, I don't. So that was the genesis of this opinion. And what you're referring to in terms of you go eyes open, if it's spelled out in the contract, that is the freedom of contract position, that counter argument to this opinion. But there are certain things that are just not permissible ethically. And the Scapa Brown case that we reference in the draft now that we've been talking about today, among many other terrible things that the attorneys did. So I'm the first to admit that the state bar really wanted to come down on these attorneys. It wasn't just for this. But among the many things they did is they said, if you discharge us, you automatically pay us $600, regardless of whether we've ever looked at your file or talked to you or whatever. And the state bar said, absolutely not. A discharge attorney only gets quantum meruit under Fracassi case. And the attorneys knew that they were violating this, and it's yet another wrongful act by them. So that's where the opinion came from some of us feeling that we see a lot of what we perceive as abuse of clients through these conversion clauses that don't ever have to get implicated or fought about. Just their existence in the contract causes clients to stick it out with terrible attorneys sometimes. That's where we're coming from. And there are all sorts of counter arguments about freedom of contract and sophisticated litigants. And, so that's sort of what we're hashing through here. And unfortunately, Raquel, this does predate you joining the committee. And we have departed from redlining the draft itself for a very long time while we try to hash out where do we even stand? Where do we want to go, if anywhere, on this? So that's just my background. I welcome anyone else to talk about it.
Thank you.
And Raquel, I would just add to that, because the cases and the ethics opinions from out of state to discuss this, they also point out that, with rare exceptions, the lawyer and the client aren't really of equal knowledge or bargaining position when they enter into the fee agreement. So how wide open, is the client? The client's desperate to get, legal representation and may not understand the ramifications. And that's why I once again, I look back at the ethics opinion in the other states. While they somewhat qualify things, they ultimately come down to the conclusion that, this type of provision really can't be done. And somebody was mentioning the conclusion in our opinion. I don't see what's per se wrong with our opinion, our conclusion, because it says conversion clauses are not ethically prohibited per se, but must be carefully scrutinized on a case-by-case basis, including application of the factors identified above.
Well, Ken, that's what we proposed to change, because that was only based on hypothetical 5, which we rejected. That old draft.
The next sentence talks about, when it interferes with the right to terminate or whatever, they are unconscionable. They're ethically prohibited, and when it would result in an unconscionable fee, it's ethically prohibited. So,
Raquel, also.
Sorry, Ken, just to clarify, that was a different standard, Ken, what you just said. Then are you guys on the same page with the draft? You're saying if it's unconscionable?
This is
No.
Just to clarify, the draft that's been circulated does not reflect the current recommendation of the working group per the memo. Right. So what Ken was reading from was an earlier draft where the committee didn't agree to a per se prohibition. It was one where we were having a little more flexibility.
When
I'm reading for the one that we have right in front of us.
Ken, hang on. When I got to this, it was agreed at our drafting session that I would try and answer the question about the core issue as a conceptual matter.
Yeah.
I submitted it to Erica. I did not submit a new draft, principally because I couldn't really find it. And the old one I had long been passed. And Erica, being the good person she is, thorough, attached that draft. It was not the draft that we were recommending, okay? I just wanted to get the core question answered of, are we comfortable with an opinion that says is ethically impermissible. Now, getting back to Raquel's question, two things. Number one, the freedom of contract isn't necessarily presumed in the situation of a personal injury, and the advertising rules and all. And a lot of the cases speak to that the attorney bears the burden of proving that it was not overreaching. But even so, what informed me beyond that was the cases which I cited in the memo, which I just sent to the committee, particularly the, oh gosh, what's the name of that case? Hang on, let me get it. The Arnault case. In that case, was sophisticated clients looking to save about $90 million in taxes, agreed to initially a 1% and then a 3% contingent fee based on the amount of tax savings. No doubt, totally sophisticated parties. The contract failed to include the language required by 6147, which says that the contingent amount is negotiable and it's not set by contract. The court voided it and said, no, you're not entitled to that contingent fee. And they addressed the issue of any unfairness to the client, to the attorney, by saying that you get it, the unfairness is compensated by quantum merit, and to protect the public policy of the statute, which was expressed when the legislature put that requirement in the contract, that's going to be the way it has to be, quantum merit. The same thing happened in Chambers versus Kay, where they didn't have a complying fee splitting agreement. Again, required by the rules to be in a written contract. And they were held to, the contract was void because it didn't comply with the rules of professional contract. And then in the Wilkinson case, which followed up on that, they discussed about how you can have quantum merit in a fee split, but you cannot measure the quantum merit by the amount of the contract, because if you did, you wouldn't be enforcing the public policy behind the requirement of having the contract in writing. So you go to all those cases and they instruct me, in any event, that when the legislature provides for quantum merit, that's what the attorney gets in the face of an argument that, you know, oh, this statute that enforces a public policy is unfair to me, the attorney.
I wanted to just follow up on what Raquel was saying too briefly, because I thought it was an important point, because you know, I think her example was a situation where maybe that it's something that the client might be insisting on, a conversion clause, because the client might want certainty that if I terminate the relationship before it concludes, what are my responsibilities for fees, and ensure that they wouldn't be responsible for the full contingency, and they might want some certainty in terms of the fees. And it could be a very sophisticated client. And I know that you know, the Ramirez and other cases do talk a lot about the negotiation of an attorney-client fee agreement, be it an arm's length transaction. And so I do think, and I think Ken made this point, that it's, you know, it might be rare, the situation where a conversion clause would be permissible, but I just don't think in all situations it's not permissiable.
Sarah, the sophisticated client argument didn't pass muster in the Arnall case.
That case is not dealing with a conversion clause like we have it. But I had another question though, and this question was for, I don't know if he's still on. I'm looking at the screen. I don't see Brandon. Oh yeah, sorry, I see you now. But because you did, you know, I understood your point that you were making. I didn't get a chance to respond to it yet, but about the out-of-state opinions, and I understand the way that you were looking at it, which does make some sense to me. I do think that's a logical way of viewing those cases, and so I understand where you're coming from. But the one point I struggle with a little bit is when I look at our rule dealing with unconscionable fees, Rule 1.5, and you compare it, for example, to the ABA model rule. And I think even if you look at the arbitration advisory on how to determine a reasonable fee, they all look at the same factors, even though our standard is, you know, unconscionable. So the question I have is really, do you view quantum merit as being the same as looking at the factors in ABA model rule 1.5 for determining what is a reasonable fee?
I think that the arbitration advisory.
Just because he had raised the point, Joel.
Oh, no, I actually don't have a real answer to that. I'd have to look back at that because I have viewed a reasonable fee and quantum merit as interchangeable, but the shocks the conscience level that you need for unconscionability is not present. But I don't feel qualified to speak further on that until I look at it better.
Okay, and Joel, sorry, I just wanted to make sure I didn't, because it looked like Brad was speaking, but okay.
Well, you know, the California, I can't remember if it's an ethics rule or a case, has held that the ABA rules are not binding on California lawyers or advisory only. Nevertheless, in almost all the reasonable fee determinations that I've been involved with, you do a lodestar analysis roughly similar to the ABA factors, as well as you look at the unconscionable factors, but you just don't give anything above reasonable value unless there's a complying contract that you're enforcing. And but those kind of factors, it's just kind of the weight. In other words, if a $1,000 an hour fee is not unconscionable, but it's more than reasonable, you only get the $1,000 if you've got a written contract that's enforceable. Otherwise, your beauty is in the mind of the beholder of what the reasonable community standard is, which might be $400. So that's the difference. You still look at the rate. What's the appropriate rate in the community? What's the sophistication? All the factors that go into that. And that's the analysis that you give to determining the reasonable fee that's awarded to the attorney at the end of the case. You've got all that.
Yeah, no, that's a helpful explanation. I want to be mindful of time because and I know that Brandon had initially proposed doing a straw poll, which I think makes sense to move to. But before we do, I just want to make sure, because I know, and you certainly don't have to speak, but I know if Eleanor or Elizabeth, are there any points you wanted to make before you move on to that straw poll?
Well,
go ahead.
No, I was just going to say, I think that we're at the point where Brandon's correct. Let's just take a straw vote. And if the opinion of the committee is that they won't agree to this opinion going out without exception, I personally will withdraw it. But let's just get it over with. We've been kicking this around here, same arguments.
Joel, I think Sarah's point is we're going to do that after we hear from Elizabeth and Eleanor.
Elizabeth had a point to make quickly, or
I don't have a point to make. I'm just in agreement with the opinion. I'm also a plaintiff's legal mal and professional responsibility lawyer. We do come in up against these issues, and I think it's an important opinion, and I'm very supportive of it.
Okay, so at this stage, I think we will move to the straw poll, and I do want to make sure that everyone understands too, as we're going through the straw poll, and maybe Brandon or Joel, you want to take the kind of lead on introducing the straw poll, but just to clarify, when we're talking about this opinion too, it's not the opinion that we have in front of us. It's just whether you agree. I think we're looking at whether we agree with the working group recommendation that conversion clauses in all instances are prohibited, or conversion clauses in most circumstances are prohibited. I don't know if that's a great way of framing it. You can clarify.
Yeah, maybe we could do a couple questions, because the first question I want to run by is, do we agree with a conclusion that a conversion clause may not exceed quantum merit? And then we can go to some other questions, but let's just may not exceed quantum merit.
So conversion clause may not exceed quantum merit. A yes would be it cannot.
Cannot. Yes, cannot.
Maybe we need a yes, no, and I'm not sure yet category here.
Sure, that's fine. We believe in candor. We all believe in candor.
Yes or no? We gotta force ourselves to make a decision.
That's gotta be.
Yeah.
Okay,
So-
so
Are we doing 3 options? Yes, no, not sure, or yes and no?
just, I think maybe, can you, since it's a straw poll, can you just abstain if you want to not pick a side?
Yeah,
I mean,
no. Pick a side. Pick a side. Pick a side.
see what yes and no means again.
Sure, okay. So conversion clause cannot exceed quantum merit. Yes means you agree that a conversion clause cannot exceed quantum merit. I think a no would be you disagree or you don't know yet, frankly.
Okay, gotcha. All right, taking the vote. Bacon,
Yes.
Brown,
Yes.
Bradley,
Yes.
Chivers, Krieger,
Yes.
Mark,
Yes.
Mercado, no, Munoz, O'Reilly,
Yes.
Poindexter, Starr, and Benola.
No.
Okay, so we have 6 yeses and 2 noes.
Does Justin not get to?
So I get 4 votes.
Yeah, right.
He's an advisor, so normally does not get to vote. Do you have an in here, Justin?
My vote would be no.
I didn't hear Raquel, did she?
Raquel voted yes.
I voted yes. So the
Okay.
people that voted no, is there something that could be adjusted that would get your yes? Or is too black and white? It's not, there's no gray area.
Well,
Not on that
I need
precedent.
to look at it. Sorry, I think I need to take a look at it, but I do think we're talking about a standard of reasonable and, but the standard in California is unconscionable, right? So I'm struggling with that right now.
Tell you what, let's do this. Let's take that vote. I'll take one more draft if Erica will send me a clean version of the Word document that I can work with. We'll go from the assumption that we just had the majority yes on, and we'll come back at the next meeting. And if Justin wants to not have to vote on this one more time, you're about done, Justin, right?
it's my last meeting next time, so you'll get all my candor. Don't worry.
Okay, all right. Bring it, buddy.
Careful what you wish for.
But let's do that. And that way we're not looking at an old draft. You'll know exactly what our current thinking is, informed by this straw poll. And let's get this resolved. Okay?
Yeah, I would just add, can I just add, because part of the frustration that we've had as a subcommittee is, we've had this resistance, and we've worked long and hard and scratched our brains to come up with a scenario that would support the counter argument. And we haven't been able to do it. And we haven't seen it in the other ethics opinions. And if people really think that there's another scenario there that somehow would address that, then give it to us.
And can I actually thought the scenario, you had a scenario there that initially was one that might meet it. Just answering that question too, the hypo I gave, I've tried to give, I haven't given all the facts, but that I mentioned earlier about a situation where you're dealing with a very sophisticated client who insists on the conversion clause, and it doesn't result in
Let me ask you, I want to ask you a favor, if you would.
This is a scenario where when you get the result you want, you keep talking. Is that where we are?
No. Listen, I started this well over a year ago, and I actually had brain surgery between then and now. If you've got another scenario, give it to me in writing. We'll include that in the presentation. and let's take it up at the next meeting because we've got other stuff on this agenda, okay?
Sure, and Raquel had asked a question, I think directed earlier to Eleanor and me, and I just wanted to briefly respond to that. And her question was, is there something that, you know, could convince me to move my no to a yes vote? And here's the thing that I am struggling with, and is I'm looking at where, as long as the fee is not unconscionable and does not interfere with the client's right to terminate counsel, which to me could happen in many situations where there's a sophisticated client, even though it might be more than reasonable, but not unconscionable. And the sophisticated client who's a big corporation could still terminate the attorney, and it won't interfere with that right. I am struggling with that type of situation where I view that the conversion clause will result in a fee that's not unconscionable and that doesn't interfere with the client's right to terminate counsel or interfere with the right to settle. And I that's where I feel that.
Okay.
That could be greater than quantum merit.
Put that in the question with your hypothetical or no hypothetical. Just send me that in writing. I'll do my best to answer that question. If you answer the question of why you think it doesn't interfere with the client's right to change counsel, if it's above reasonable, and then we can have a we'll focus, okay?
But I think you're starting out with this assumption that because the client negotiated to not pay in the front end, they're being harmed by having to make some payment. We don't know when or how that payment's going to be made, and they've had a benefit of not paying. So it strikes me that there's like, I don't know, I mean, maybe it's my own bias, but it strikes me that there's a bias in the analysis.
Well, if there is bias in the analysis, it's the fact that, I don't know, between Ken, Brandon, and I, we maybe handled a couple of hundred fee disputes over this issue. And we've not been able to come up with a scenario where one was felt to be justifiable in our mind. But again, I'll try and address that the next go around. And we'll go from there. But we've got other
scenarios. Maybe if you could circulate the draft when you've addressed it sooner than later, we could spend some time taking a look at it and respond in writing to the next meetings as well.
The 5 scenarios we have are in the draft that was circulated.
So the scenarios won't. I thought I was hearing Joel say he was going to go take it away and try and address
the one that was in doubt was the 5th scenario. Was that in this? Yeah, I think we give Brandon credit for this. He came up with, he strained on this, came up with a pretty far-fetched situation that might possibly work. None of us had ever seen or heard of anything along the lines of that scenario. And there was some criticism of that one scenario in the comments that we did get back, that it was unrealistic and would never happen. So why is it there? And Sarah, just to get back to you too, if you look, it was in November last year, there was an email from Angela that's got all the comments in there. There was quite a few of them.
Thanks.
Yeah, would it be possible for staff to circulate the public comments again? Just because I think we're really sharpening the issues, and I think it might benefit the committee members to.
Yeah, and the closest thing that would come to, I mean, you know, for those who are reluctant with the opinion as it exists, there was that one 13 or 14 page comment by an anonymous person. And that person did lay out what they thought were some scenarios where it might pass ethical muster. We went through that and we disagreed with those, but they're there if you want to look at those.
Thanks, Ken. That's helpful.
All right.
I think I'm going to turn to the next agenda item because we only have a little bit of time, which, you know, I think I might have skipped an item by mistake.
Yeah, it's the ruling.
Yeah,
I can talk really quickly.
So Erica is going to talk briefly on the implementation of Rule 8.3.
Sure. So at the request of a few committee members, there wanted to be an update on basically what's happening with Rule 8.3. So it goes into effect, I think next Tuesday is the actual date, August 1st. And so staff in Office of Professional Competence and other state bar staff have been working on basically how the rule will roll out. So there's going to be a lot of education coming out of the Office of Professional Competence. There's going to be a dedicated web page on the State Bar website to clarify essentially how you can report and where you can report. So it's the exact same process as already exists for anyone who wants to file a complaint, be it a member of the public or an attorney. We are updating the attorney complaint form to reflect, to make it possible to indicate that you're an attorney reporting pursuant to Rule 8.3. And then obviously we're going to track that information so that we can track complaints that are being reported as filed for that purpose, so that we can have some data to report back as to whether or not it is being weaponized, or those types of concerns that many members of the public comment and others have brought as part of the Rule 8.3 implementation. As far as the education component, our office is, like I said, there's going to be a standalone web page that addresses this on the State Bar website, linking out to many other pages that address, self-reporting obligations and those types of things, so that people don't think 8.3 is their only reporting obligation. There's going to be an FAQ. We're working through some possible scenarios to include, and then our office will be hosting a few MCLE presentations on Rule 8.3, as well as working with other bar organizations to develop basically presentation content for them to take and utilize to educate their members on the new obligations. So, a little bit different rollout for this one because there's affirmative obligations in the rule. So we are trying to make sure that everyone knows who hasn't been reading about it in various media outlets that this is coming, and basically how to handle it appropriately.
Can I ask a question on this? Is it staff's conclusion that 8.3 is retroactive in perpetuity?
So the duty to report would likely be prospective, because most rules are prospective, but you're going to, each attorney, at least my interpretation is that each attorney is going to have to determine whether or not their knowledge starts on August 1st or not. So that's where this is an interesting, yeah, exactly. So
10 years ago, I learned something terrible, and well, it's really weird for legal mal cases, because now
yeah, sure.
Legal mal attorneys now have to think about whether a lot of the people we've sued and resolved matters over many, many years, do those facts rise to mandatory reporting facts? But I'm just wondering if the State Bar staff or we have any insight into whether this goes back like forever, or because I know what I know.
Right. Well, that's exactly the issue. So there was in several of the comments a request to clarify that the duty to report only applies to conduct that is known on or after August 1st, right? And that was not something that was added to the rule. So, taking the legislative history, if you will, or basically the board history and the board item, out of an abundance of caution, my inference would be that if you knew something on July 25th, 2023, you would report it in compliance with Rule 8.3 August 1st or thereafter. I would not doubt that'll be something that is litigated if it ever gets to that level. But that would be my interpretation. In my personal capacity, I obviously don't work in OCTC, so I can't say how they would.
Has OCTC issued any guidance, or are they approachable for communications on that point, which is of great administrative curiosity to certain practitioners?
Sure. So my understanding is that OCTC does not issue guidance because, similar in some ways to the ethics hotline, you don't get the full picture on a lot of things. And so, oftentimes it's resources. With CTAP and with 8.3, the State Bar is taking a bit of a different approach than it has in the past. Obviously, when the 2018 rules rolled out, There was some education that was provided by the committee members for the Rules Revision Commission. But these are CTAP and 8.3 are a little bit different than many of the rules in the sense that there are really much more affirmative obligations than exist in a lot of the rules. So we're trying to the extent we can, provide a bit more education on those things. But I don't think, Brandon, to better answer your question, I don't think OCTC themselves is going to come up with any guidance or safe harbor provisions of that kind, at least to my knowledge right now.
If the anecdotal evidence we heard is true, there won't be any calls anyway, so you'll be all right. Because nobody reports under 8.3 in any state.
That's interesting because in my legal network, I am already having people say that people are weaponizing it in their view, like, oh, and citing 8.3. Like, oh, they didn't keep their promise. And they're like, 8.3 is not about keeping promises.
Wait till the civility rules come out, then we'll see.
Yeah, so there is, so I have concern in us just watching it because, you know, I think part of the conversation in the public comments was that people thought people would weaponize it, and particularly when they think it's to their advantage. Small firms against general practitioners, more against females. So already people, and people have shared sort of things with me, emails or documentation that has come to them that said the state bar is going to have this new rule on August 1st, 8.3, and you know, we can use this now for this behavior. So you know how California is, we got to lead in everything. So if no one else is doing it, we sure will be doing it.
Could be, that's true.
Do we have an opinion from any other jurisdiction where, I mean, under our rules, that to threaten to bring an administrative proceeding, such as a state bar complaint, to gain an advantage in the civil litigation is a ethical violation? Is the phrase, you know, I've got an obligation under 8.3 to do something about what I'm seeing here, is that a violation of the ethical rule against threatening a state bar proceeding? That's an interesting question. I don't know if there's any other authority that's actually tackled that, but if there is, I'd like to know.
Hey, Brandon, that's a good point. I hadn't thought about the point you raised, but you know, doing plaintiff legal malpractice cases, many of which involve highly questionable acts by the defendant lawyer, it hadn't occurred to me that I might have to report that to the state bar now while prosecuting the case.
Erica?
Yes.
And I'm just curious, what I mean, based on what you know about 8.3 and what's being said, what do you think? Not that you're the authority, but you know.
Whether saying you have to report under 310 or under 8.3 would violate 310? Is that the question?
Well, I don't know the numbers for sure. If that's those numbers, if those numbers reflect, I don't know the numbers.
I don't know that California has addressed this in that level of detail. I would have to look to other jurisdictions to see if they have, you know, guidance on the intersection between 8.3 and 310 to the extent that the other jurisdictions have a 3.10. I'm looking at the resources that we have. I mean, we have a really old ethics opinion, 1991-124, that addresses the language you can use, essentially like safe harbor language under the old Rule 5100, and it just, all legal remedies will be pursued was something you could say. And then, you know, there's case law, but the case law on this is, I think Crane is the most recent, and it's from the 1980s and has nothing to do with 8.3. So I'm not sure there's enough to give a true answer on that. Certainly something that this committee could take up.
Yeah, I do think that would be a good topic, because that is weaponization is a major concern that's been expressed, and that would certainly be one way to really weaponize the rule if people were to go about threatening to report other attorneys.
Well, you know, if you don't report, I mean, if you don't threaten or mention it and you report, you're not in violation, obviously.
Yeah.
But if you just bring up in casual conversation, gee, I wonder if I have an obligation under 8.3 to do something about what I just saw you do. Is that a threat that violates 310?
I think if you're using it to obtain advantage, it could be.
So we're now a little after 4. I'm going to move on to the next item on the agenda, which is the illegal contracts ethics opinion. And I don't think we need to spend too much time right now, but we addressed this, I believe, very briefly at not the last meeting, the meeting before, so about 2 meetings ago. And the issue we were debating is we had made some edits to address some comments that we had received, and some of the pushback relates to the example in the opinion dealing with a non-compete in an employment law agreement, even though there are kind of clarifications that we're not opining on whether a particular provision violates the law, but we're opining on any sort of a legal provision in the contract. But at the same time, there was a lot of pushback, and there is a pending proposed FTC rule that would ban non-competes outright and really clarify across the board that they're illegal. But that's unlikely to be voted on until April of next year. So I think initially we were kind of in a hold pattern. Well, let's see, because we weren't sure about the status of that and some California proposed bills that are now no longer going to materialize. But the issue is whether to move forward with the opinion or not. And so that's one question. And the other, issue that we were discussing briefly is whether we really need to provide this example in the opinion of the non-compete. Can we simply maybe remove and here, I guess if we can, I gotta look at my notes on here. So if you could go to the top, could you scroll up a little bit? So one alternative, just to the introduction I'm looking for. So if you look at the introduction, the second sentence, for example, provisions in employment contracts that impair the ability of employees to compete against their employers following termination of employment have been found to be illegal and enforceable, blah, blah, blah. So we could consider just striking that language following the first sentence. And then similarly, footnote 3 that, goes with that, which is really citing to the case law in California to support that proposition. And then at the same time, I think if we made that particular edit, we wouldn't necessarily need, initially, the part that's in red line here, just for background, was added to the body, and it used to be in footnote 2. And that was because it seemed that from the public comments, some of the public comments seemed to be concerned about this issue. So we thought maybe we should put it in the body as opposed to in the footnote and expand upon it. But I think if we are removing that one example, we could consider just leaving the opinion as it was initially with footnote 2 and the kind of the clarification falling in footnote 2 as opposed to here in the body. And so by removing the example, I don't know, because so much time has passed, if everyone recalls kind of the history of this opinion, but it related to requests, I think, by different nonprofit groups and others about concerns that in California, particularly, employees are being forced to sign these agreements with illegal non-competes, and a concern that whether that practice could violate the rules of professional conduct. So I think that's why initially the drafting team chose to provide that particular example, which does appear to be supported by the case law, but at the same time, as you know, we don't opine on issues of law. And that was causing some issues. And this opinion, I think, is clarifying that we're addressing the very narrow situation where it's clearly, the provision of the employment law contract is clearly illegal. I don't know that we need to provide the particular example. Certainly, I think if the FTC were to down the road adopt a rule, it would be hard to argue in that sense that it, you know, there's some sort of argument that it might be legal, as opposed to just referring to case law in California. But I kind of want to just pause because I've been speaking for a while about the questions posed are really, do we go ahead and move forward with this opinion? Or do we wait and see what happens with the FTC? And then second, if we do move forward, should we make some of the edits that I was suggesting to remove the example of non-competes? I guess this happens after 4. No response.
You want me to talk?
Sure.
So I think I don't have any issue with what's on the screen, the blue language staying. I do wonder if the opinion needs an example. I'm trying to think of if there is an opinion that CoCRAG has issued that doesn't include an example. I'd have to look. But I don't think that what you've added there actually harms that.
And I feel like we've done opinions like that with that examples. I recall Dina, our former member, was very good at issuing concise, or taking the lead in drafting concise opinions. And I feel like one of the ones she worked on, I think we decided not to even have a hypothetical perhaps in that particular opinion. I can't remember what it was at the moment, but I don't know that we've had examples of every.
I have a question. So I was looking at the draft California bill, which I don't know what the status of that is. I saw that looks like it was amended in July of 2023 or something, but that language would make the conduct of enforcing a non-compete illegal, like expressly under the law, as opposed to just 16600, which just says that kind of a provision is voidable. And so if we're just talking about a contract provision that is arguably illegal, don't we need some kind of authority that says that the conduct of including, advocating, or trying to enforce an illegal contract provision is illegal in order for the rule to apply? We're, looking at the difference between the conduct of it and just the kind of nature of or characteristic of the provision that we're talking about. And I've always had an issue with this because, like, from the beginning, what are the other examples besides a non-compete where this is going to come up? And if it's coming up in legislation, I think that's an appropriate place. And if once there is legislation, then do we need the opinion? Because the legislation is then deciding that the conduct itself is illegal. Like under 16600.1, which I guess is the new proposed language in this July draft. I'm trying to read this legislative history, but it says it shall be unlawful to include a non-compete clause in an employment contract, which is much different than just saying a non-compete clause is void.
Elizabeth, is that AB 747 that you're looking at? Just so we're all on the same page.
1076. This morning is the first time that I looked at this, but I just was Googling to try to find out what the status was, and I came up on this, and it's proposed, they're proposing removing the proposal from 16600C and creating 16600.1, which would say it shall be unlawful to include a non-compete clause in an employment contract or to require an employee to enter a non-compete that does not satisfy an exception in this chapter. And it also says a violation of this section constitutes an act of unfair competition within the meaning of Chapter 5, commencing with Section 17200. And so, you know, some of us have argued in practice that including this type of a provision is a violation of 17200, but there's no statute, you know, that says that. This is proposing to codify that being a violation of 17200. And if that's codified either through this bill or another bill, then why do we need the opinion? Because it would clearly be illegal conduct that it doesn't seem like it would be a gray area.
Did you Google it or did you AI it? Just kidding.
I'm on legiscan.com/ca/tech/AB1076. And it says for the 2023-2024 regular session, amended status, July 10, 2023. Read a second time and amended. Referred to Committee on Appropriations. I guess I could put the link in the chat somehow. I gotta type it in there. It's on a different computer, but
Elizabeth, I'm wondering if the specifics of this bill don't necessarily, because we're considering taking out some of the example out of the opinion itself, it doesn't really change the more fundamental question about if the inclusion or advocacy of the provision itself is automatically illegal. Do you need the opinion of that, right? And if it's not, if it's just voidable, is the opinion even correct? That's where I'm hung up on this opinion. I don't know if I expressed that intelligently.
I just didn't hear the tail end of what you said. I'm sorry.
Oh, so if it is illegal even to include a provision, as contrasted with it just being voidable, it's obviously illegal conduct that an attorney can't engage in. You're assisting it, and so then the question is it so obvious that whether the opinion is necessary at all? And then if it's not illegal to proffer it, to include it, but it's simply voidable, is the opinion even correct, right? Is the opinion overstating the case? And that's my hang up on this opinion.
I'm not clear I'm quite following, Brandon, what you're saying, because I think the opinion is not addressing a situation where it's merely voidable. It tries to make clear that we're just in a situation where the provision is illegal and not subject to an exception. So I think that's the intent of this opinion.
My confusion, it has to do with what it means for something to be illegal. Does that mean, you know, because there's illegal things that just will never be enforced by a court of law, or it is against the law to include it, or against the law to even suggest it or present it. And I'm just a little nebulous on that. And I know we've gone through it a bunch, and I apologize. I might just be being slow on this one, but I've been hung up on this one.
No, I totally agree with you, Brandon. And 16600A, as it's currently drafted, just says that the provision is void. I mean, I also do plaintiff's employment work, so I don't like the current state of the law. I welcome a change in the statute, but whether the opinion is either on the mark or necessary is a different question.
So
it doesn't say it's illegal. It just says it's void. It just says that the contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. And in my practice, that provision ends up getting voided. It doesn't void the entire contract. Employer just can't enforce that provision.
yeah, so just to clarify, I think you guys are both raising somewhat different issues, but the first issue is just, if we leave in this example, I think there's a debate on whether, if it's merely, if we're talking about a non-compete example, if that's merely voidable, does that really result in a violation of the rule as opposed to illegal? And I think that has really caused a lot of debate. And that for that reason, I'm leaning in favor of removing kind of the example altogether. But I don't think removing it answers a second question. And I do also think that some of the authorities, like, I don't know, Brown, for example, an employer's use of an illegal non-compete also violates the unfair competition law 17200. That is showing the use of the non-compete violates the law. But I don't think we really need to, I think getting into a debate on whether, a non-compete violates the law or is merely voidable, I don't think that's something we should really address. And I think maybe we can, even though it would be, I think we could avoid it by taking the example out of the opinion, but then we'd still have to evaluate, I think this is where Brandon was going a little bit in terms of by including an illegal provision in a contract, is the attorney violating their ethical obligations? And that's what the opinion really addresses, current draft. But I'd like to hear others' thought, or maybe just that initial question is whether we feel that we should remove this example or not. And then we can, maybe we need to reevaluate the opinion after removing the example.
It's a bit challenging to answer because removing the example is going to dramatically alter the opinion, like just what's on the screen, the statement of facts, right? That's all going to change theoretically. It's talking about employment law advice and all of that. So it's going to look very different. And so then the question would be, if we kind of cleanse the opinion of anything related to employment law, what's the utility of an opinion that kind of abstractly addresses the ethical issues with lawyers presenting or advocating or enforcing illegal contract provisions or something illegal, whatever that is? Is it too abstract at that point to be useful for the reader? And
so this came up in the public comment, which I recently reread, and that was, I mean, I think the big issue was if you set aside the example of the non-compete, there was debate over whether or not placing an truly illegal provision in a contract violated 1.2.1. And that was where basically the debate was, with many saying, yes, it does, and that's what the opinion concludes, and others saying, I think that's too much of a leap. Because it's not actually assisting in the violation of law, it's putting a term in a contract, and then maybe the enforcement of that would be assisting in the violation of the law, or maybe you're arguing that it's an invalid issue. So I think there's still value in the opinion if you remove that example. I'm wondering if there's a different example that would exist though outside of the employment context.
I haven't been able to think of any, and I think if there's some law that says that the client conduct is in violation of the law, like including this, that, or the other in a contract, is a violation of the law, then it makes sense to me that the lawyer's inclusion of it is a violation of the law. But without language saying that the client's conduct is illegal, I don't get how you get to the lawyer's conduct being illegal.
Yeah, and Elizabeth, following up on that point, and the point that Justin is making as well, in terms of, well, if we remove this example, you know, we'd have to remove the whole kind of context of arising in an employment law matter. But I do want to point out that note 16 of the opinion refers to Labor Code section 432.5, which does say that no employer shall require an employee to agree in writing to a term that is prohibited by law. So we could rely more heavily on that Labor Code provision without specifying the particular provision, but just rely more on Labor Code 432.5. But I think actually we had this in the initial opinion, but it was also, I think, put it out in, I think it was former trustee Sean Lee comments when he was, he had raised that Labor Code section as well as something to consider. And maybe one other public comment. So we could try to, you know, remove the example and rely a little bit on that Labor Code section. That way we don't have to remove all of the kind of context of how this issue arises. But there's still the ultimate issue that Erica raised, is whether we agree with kind of the ultimate conclusion that the Attorneys Act, including this illegal provision, violates Rule 1.2.1, and we also address other rules to the extent, you know, the employer or the lawyer misrepresents the legality of the provision in negotiations with the employee.
I don't know. I guess I still come to a kind of a confusion with there needs to be something that says the conduct is illegal. But then if there is something that says the conduct is illegal, then why do we need the opinion? Because it would clearly fall within the rule.
Well, here,
I think,
sorry,
go ahead.
I was just saying here that particular example, if we're just following up on the Labor Code provision, which to me, it does say the conduct is illegal of the employer. I guess it says no employer or agent, manager, superintendent, or officer shall require an employer applicant to agree in writing. I don't think that it's necessarily clear to attorneys that including it in a legal provision in a contract violates the law. But I think maybe I'm misunderstanding what you're saying, Elizabeth, but you might be saying that you don't agree unless there's a provision that clearly says the act of including the provision is illegal in itself, that merely including an illegal provision in a contract would violate 1.2.1.
Yeah, I mean, I think if there's the law that says it's illegal, we can just say it's illegal, and therefore it would be illegal for the attorney to include it.
That was what I was trying to say really clumsily earlier.
Like if we assume the client's conduct is illegal, and that Labor Code may be a good example, then that using that code as an assumption that the conduct of the client is illegal, then that follows, as opposed to just this provision is illegal.
So I was thinking about this provision a bit.
That came up in the public comments, I think. So it seems like we're divided too on that particular issue.
I was thinking about the genesis of this opinion, and my suspicion is that it was suggested not because the provision, the contractual term was plainly illegal. I thought it was the law isn't clear enough. These things are unenforceable, and attorneys shouldn't be putting things in contracts that are unenforceable because it has a chilling effect, which is an interesting ethical concept, but it doesn't really square with this illegality provision. Because I see it sort of like Elizabeth does, whereas if the act of putting this in a contract is illegal, absolutely, and of course, the attorney can't do it and can't assist with it. But if it's just unenforceable, I thought what the requester of this opinion was looking for was something saying we shouldn't be going around as attorneys creating chilling effects, making people think they don't have rights when they do, things like that. I thought, and it's not as neat as illegal. It doesn't. That's my recollection.
So interesting. Yeah, before I started working at the bar, I was the one that wrote the letter requesting this opinion.
Well, all right.
Yeah. However, that was, I think, 4 years ago, if not 5. And so I don't remember specifically now. And so I think I'm going to dig that up. We can dig it up and we can circulate it to you to the extent that's helpful. But I do think it, as you were talking, Sarah, it really was about like the ethical issues involved and, you know, knowing that something might be unenforceable, but putting it in the contract anyway. What does that mean? What kind of ethical responsibilities does that place on the attorney? But I think at the time, the law maybe wasn't as, like as you're saying, Elizabeth, now there might be a statute making it much more clear. Before it was in case law, but maybe it wasn't so clear. And so again, who knows what will happen with the statute is the other thing. I mean, I don't know if this bill where it will go. We're in the beginning of a 2-year session, so it might not even go this year. It could be next year if it goes at all, or if it gets amended. So anyway, there's a lot of unknowns, and it's late in the day too. So I don't want to take up time with my own opinions about it. But I just thought it was kind of funny when you were talking about the requester, because it was me.
Well, that's really interesting. Thank you.
It was from the Center for Public Interest Law at University of San Diego Law School.
Okay.
Yeah. But Brenda, I was just had a quick question so are you caught up on putting aside the unenforceable thing? If a provision is illegal, but let's say there's no law that says the act of including the provision is illegal, are you of the opinion that the attorney wouldn't violate ethical obligations by including an illegal provision in a
I think that's
contract?
I think if I'm remembering right, and again, I don't remember exactly how it was worded, but I do think that was the gist of what the request was asking you all to look at.
Yeah, so this is either an admission of ignorance or some wonderful insight. I literally don't know what it means to be illegal if the result is that the thing's just not enforceable. But if it is against a law to even include it, then I'm absolutely on board. 1.2 prohibit, or is it whatever, prohibits it. You can't assist in an illegal act. But if it is just going to be unenforceable, I don't think illegality is the lens through which to view it if we think it's improper or unethical for attorneys to be confusing others into thinking they don't have rights that they do. If that's the
right. I think that's really what it was about. It was, you know, in the context of employment contracts, particularly, that's my recollection, is that's really what the issue was, is whether or not you intend to ever enforce it, right? But what kind of impact might it be having on an employee by just having it in there at all? And what kind of ethical obligations does that raise?
I mean, I think separately, that's an important issue, but I think we just need to be careful to not make illegal, unenforceable, or void synonymous, because they're not necessarily synonymous.
Yes, and that's why I don't want to weigh in on any of that, because I haven't been focusing on this or at all, and I don't even remember the original language of what we had in the letter. So we can definitely, I don't know how you want to handle it at this moment.
Here's one example.
Dig it up.
An example that occurred to me when I was reading this latest draft is that the Mandatory Fee Arbitration Act says you cannot, in your fee agreement, compel someone to agree to binding arbitration before the dispute even arises. The law is clear that both parties can agree to make it binding after the dispute arises. But I see this in tons of contracts. I don't know if it's intentional or not, but it's contrary to the law. It is against the law. Is it an illegal act? I mean, it's unenforceable. It's patently unenforceable, but is it an illegal act? I don't think so, but I'm confused by this. And again, I should just stop.
Same with jury waivers. Same with jury waivers.
Yeah.
If memory serves you correct, that was a lot of the comments that we got back with the draft when it went out was what is illegal? And, you know, and how was that defined and whether it was too loose, but. But you're right, Brandon, it's patently illegal.
Sure. So I realize the time, but is it maybe that it's a 4.1 8.4C issue and not a 1.2.1 issue at this point? If we're struggling over illegal versus unenforceable? And
it is for me. It is for me. And I don't actually know exactly, I know normatively what I would prefer the outcome to be, but I don't know if the rule stretches that far.
Sure.
But I think that's the path to be analyzed.
Sure, and that I think that's in the opinion that the 4.1 and 8.4 analysis, there's just also the 1.2.1 analysis, and maybe removing the 1.2.1 leap, I think that some people think it is. I'm not, that's at least what some of the public comment concerns were. Would address some of the concerns. Maybe at least Brandon's concerns, since he's nodding.
Don't make it on my concerns, because I start each comment by saying how confused I am. So let the smarter people guide this one.
I mean, I've had a very prominent ethics expert, opposing expert, you know, say it's not even a breach of fiduciary duty to have a fee agreement not in compliance with the rules or the statute, let alone, I assume his opinion would then be it was not illegal to include unenforceable contract provisions, even in fee agreements. I don't disagree. I mean, I disagree with him on the fiduciary duty issue and that particular fact pattern, which I won't go into, but it's kind of a can of worms when we're interpreting what does illegal mean on top of the issue of a scenario where there's no client conduct and it's just, you're just looking at the characteristic of a term and whether it's illegal, enforceable, void, etc.
Yeah, so I'm not, we're after 4:30, so I want to be respectful of everyone's time. I think maybe we'll have to conclude at this point, and I think at this stage, we'll have to think about this some more. Maybe members of the working group, and you know, what to do with the opinion currently, including Erica's recent suggestions, maybe, you know, focus only on 4.1 and 8.4. So I think we'll follow up, and maybe if we have questions and stuff, we'll reach out. Brendan and Elizabeth, since you guys were helpful in providing some feedback on your concerns, we'll reach out to you guys as we work through it. So thank you, everyone. I think we should conclude now that it's 4:34. Have a great weekend, everyone.
Thank you all.
Thank you. Bye.
Bye.